Evening, very warm welcome once again to your favorite channel, that is StudyIQ as English. My name is Praveen Mishra and we are continuing our chapter of fundamental rights in our series of Indian polity. So let's start the session here. In the previous class, we discussed about Article 21, that is right to life and personal liberty, and what it has stated. That no person shall be deprived of his life and personal liberty except by the procedure established by law. And where we have also discussed that the procedure established by law was kept under the scanner of question. That is, it is very vague and it is quite impossible to define the procedure established by law, and hence giving the case reference Maneka Gandhi versus Union of India 1978. The Supreme Court clearly opined that the procedure established by law is quite vague in nature, that is a very difficult thing to be defined and could easily be misused when it comes to the arbitrary reaction of the state. So in that sake, Supreme Court stated that in place of procedure established by law, the term that is from the American origin, it should be used, that is known as due process of law. That is simply speaking, any particular law that has been passed by any particular authority of the state shall be passed through the multiple checks, multiple windows of checks, and it should be clearly seen whether is it violating any of the provisions of the fundamental rights or even any of the provisions of the Constitution apart from parts outside part 3, that is other one, 4, 5, 6 and so on, right? So the case reference, guys, please make it clear. That is Maneka Gandhi versus Union of India 1978. The word procedure established by law was interpreted to be as due process of law. Okay, so one thing more that is to be added, there is no particular amendment done to the Article 21. Still the word procedure established by law is only mentioned. The only fact that is we need to remember here, just the interpretation of the procedure established by law has changed. Okay, so it is due process of law, that's it. Okay, so coming to the next one, that is, we also discussed this in the previous class, Article 21 capital A, providing free and compulsory education to children aged between 6 to 14 years, okay, inserted through 86th Constitutional Amendment Act of 2002. Okay, now moving to the next article. Okay, Article 22, protection against arrest and detention in certain cases. What is this? According to Article 21, according to Article 22, Clause 1 of the Indian Constitution, punitive detention is there. So that is to punish a person after a trial and conviction has been done, and the available safeguards is also mentioned. That is right to be informed, that is right to consult and be defended by a legal practitioner, and right to be produced before a magistrate within 24 hours, and right to be released unless the magistrate authorize. Okay. So basically Article 22, what it talks about, protection against arrest and detention in certain cases. First thing that we need to mark here, according to Article 22 Clause 1, that is, it talks about the punishment when the trial is done, when the person has been put under the proper trial and the conviction has also been given. But it also talks about some safeguards to the individuals, those who are undergoing the trial or some type of the conviction. Okay, that is first thing. Any person who is arrested should be given the proper reason or the information of arrest. Without the proper reason or the information, the arrest cannot happen. And second thing, rights to consult and defended by a legal practitioner. Basically here, legal practitioner means an advocate. Okay, when we mention here the word legal practitioner, we are mentioning the word advocate. Okay. Next thing, right to be produced before a magistrate within 24 hours. So what is this? Let's understand. When we say right to be produced before a magistrate within 24 hours, let's say for example, there is a person, Mr. X. Okay. This Mr. X is arrested today. Okay, let's say the time is around 8 p.m. Okay, so Mr. X, his arrest has happened on 8 p.m. 2025. That is 8 p.m. What is the date today? It is 1st of April 2025. Okay. This Mr. X should be represented in front of the nearest judicial magistrate within 24 hours. Okay, how many hours? Within 24 hours. But there is a catch. What is the catch? It's this. The 24 hours do not include the time of travel. Okay, so the 24 hours, they are not inducted. They exclude what? The time of traveling. So there could be confusion existing still, but let's just eliminate the confusion as well. Right. So let's say, for example, Mr. X. Okay, this Mr. X, he has been arrested from the location, let's say, Andaman. Okay, from Andaman Island. And let's say, for example, just for an instance, the nearest magistrate available here is only in the Calcutta region. Right. And from Andaman to Calcutta, there are only two ways of traveling. Okay. That is one through the airways and second one through the waterways. And let's say, just for an example, once again, the IMD issues the notice that because of very strong winds or some type of a cyclone condition or any type of the unavoidable weather conditions, flights, they are not allowed neither to land, neither to take off in Andaman, neither in Calcutta or something like that. That is, flights, they are kept at absolute standby mode. Now, the only medium that is left is through the waters, that is ships. Okay, that is waterways. Now, from Andaman Island, traveling through waterways to Calcutta, it might take, because of the bad weather conditions, more than 24 hours. So what will happen now? As according to the provisions of the Constitution, it should be 24 hours only. Okay, that the person who is arrested should be represented in front of the judicial magistrate. What will happen? Now what will happen? Okay, now this provision is violated. Now will that person be released? That, oh, sorry, 24 hours, it is now over that, now you are free to go. No. So here the catch is, that is, the Constitution has made this thing clear, that is, the time of traveling from the person's arrest to the nearest judicial magistrate is excluded. It is not included in these 24 hours. Okay. So this is what Article 22 has to state. Okay. Article 22, Clause 1. Right. So, right to be released unless the magistrate authorizes. Next thing in the same article, that is Article 22, Clause 4 and Clause 7. It talks about preventive detention laws. Okay, what is the law? Preventive detention. See, the detentions or the arrests, they are of two types. The first one is punitive in nature, that is providing punishment. When the crime has been conducted, okay, now the trial is being done and the conviction has happened, right? The other one is punitive. No, it is preventive. What is that? The crime hasn't yet happened. Okay, the crime has not yet happened. Okay, it's just the authorities, they believe that there is a person, Mr. X or Y or Z, whatever, could commit a crime. They have a suspicious element in their minds against that one person, two-person or whatsoever, that this person could commit a crime. Could, has not yet committed. Just the suspicious activity is there. Okay, and because of that suspicious activity, the authorities now, they can arrest any individual on the grounds of prevention of a crime. And when such type of arrest happens, it is known as preventive detention. Okay. Now the fact here is, under Article 20, Clause 1, what we have discussed, that no person, okay, literally no person shall be arrested or convicted except he or she has violated any law. This is what Article 20 has to state. But on the very contrary, on the very parallel side, Article 22, Clause 4, it is talking about preventive detention. That is, a person who has not even committed any crime, but some suspicious activity has been identified by the authorities or the state, and because of that suspicious activity, or even there is some suspicion in the minds of the authorities or the state, then also they can arrest any individual person because of Article 22, Clause 4, that guarantees the authorities the preventive detention laws. Right. So Article 22 Clause 4 is basically exception to Article 20 Clause 1. Okay, as simple as that. So there are exceptions to fundamental rights, and the part 3 only, it is providing exceptions. Okay, that is Article 22 Clause 4 talking about preventive detention is an exception to Article 20. Okay, that is, on the one side, the same constitution says that no person shall be arrested, okay, because of not violation of any crime. Okay, no person shall be arrested until and unless that person has violated any law or committed any crime, basically. But on the contrary, Article 22 Clause 4 says, okay, you haven't committed any crime, then also I can arrest you on the grounds of suspicion. So that is known as preventive detention. And make this thing very clear, a very clear cut fact. India is the only democracy, only socialist democracy with preventive detention laws. With what? With preventive detention laws. No other democracy has preventive detention laws, that too guaranteed by the constitution. Okay, preventive detention laws guaranteed by the constitution itself. Okay, guaranteed what? By the constitution itself. Right or wrong? Tell me your opinion later on after the class into the comment section. Okay, so tell me your opinion. What do you think? Should India be having that preventive detention aspects, and that too guaranteed by the constitution? Do we need it? Yes or no? It's a matter of debate, but yes, I would like to have your opinion. Not now, just let's focus on the rest of the points. Later on, when you are done with the class, just have a proper research over it and let me know into the comment section whether the democracy of India, the nation of India, we the people of India, do we need the preventive detention laws? Yes, then why? And no, then why as well. Okay, so India remains the fact that is the only democracy. Okay, so as you can see, detention cannot exceed 3 months unless approved by an advisory board, and the right to be informed about the grounds of detention. And do we have any legislation on preventive detention? Then yes, we have got many laws, specifically UAPA, Unlawful Activities Prevention Act in India. Apart from that, Section 124 capital A of the IPC that talks about sedition. And yes, there were earlier previous laws that is right now all merged together, and one bigger law has been created in the name of UAPA. Earlier, there used to be the laws that is, for example, MISA, Maintenance of Internal Security Act, TADA, that is Terrorist and Disruptive Activities Act. Apart from that, there was also an act known as POTA, Prevention of Terrorist Activities Act. Okay, so the legislations, for example, okay, it was MISA, that is Maintenance of Internal Security Act. Another act was also there known as Terrorist and Disruptive Activities Prevention Act. Disruptive Activities Prevention Act. We also had POTA, Prevention of Terrorist Activities Act. Prevention of Terrorist Activities Act. Okay. Then there were other acts as well. Coffee POSA, that is Conservation of Foreign Exchange and Prevention of Smuggling Act. Okay, so simply. Okay. So TADA, POTA, MISA, they were all discontinued. Okay. Then apart from that, very freshly, one of the most needed, I will call it needed as well. Though there have been instances where people, media, and everyone, they have criticized of being of these acts being misused or misutilized. Don't know how much correct it is. Let's not just go into those dimensions of discussion, as it is baseless for at least in the UPSC CS examination. Okay, as of now, at least it is. Okay, so talking about the factors, MISA, TADA, POTA, Coffee POSA, okay, these were the acts, they are not in action anymore. But taking the provisions of this act, all of these acts, they have been submerged. Okay, so TADA plus POTA plus MISA plus this Coffee POSA and so on. Another act has been made that is known as Unlawful Activities. Unlawful Activities Prevention Act. That is simply UAPA. Okay, specifically targeting towards where section 124 capital A of the erstwhile Indian Penal Code actually, right? Okay, so I'll tell you very interesting incidents. With regard to MISA, the first name there, Maintenance of Internal Security Act. This was the act which has been criticized of being most misused act by the government during the emergency era, while the 1974-75 emergency was going on. So we have a very famous, very popular leader in India. His name is Lalu Prasad Yadav, right? Every one of us, we are aware with Lalu Prasad Yadav. Okay, how popular leader he is, this is also not a new thing. Okay, he's popular throughout the states, not just the state of Bihar. Lalu Prasad Yadav is beyond that. Okay, he is like famous outside the state of Bihar as well because of his fiery speeches and the way he speaks and everything. So we know Lalu Prasad Yadav, he has a daughter as well, and her name is Misa Bharti. Okay, what's the name? Misa Bharti. And you know it very well when it comes to the names. Misa, it is not a name. Nisha is a name. Nissa is a name. But Misa is not a name. So don't know what the exact reality is, but the people, okay, they have got this information. I don't know how much reality this possess. Okay, just I'm sharing. If you guys know whether this is a fact, this is a reality, or this is just a myth, so please do let me know into the comment section later on after the class. That Lalu Prasad Yadav, when he was arrested through the MISA Act, his wife, that is Rabdi Devi, who also became the chief minister of Bihar for a good tenure, right? So while Lalu Prasad Yadav was arrested through the MISA, that is the Maintenance of Internal Security Act, Rabdi Devi, his wife, she delivered a baby girl child, okay, and Lalu Prasad Yadav named her as MISA only. Right, okay. So once again, I would just like to quote here, I don't know how much reality this thing is, okay, having. So if you are having the clear-cut answer, so please do let me know into the comment section for sure, right? So all of these acts, MISA, TADA, POTA, Coffee POSA, they were all discontinued. And apart from that, very freshly built UAPA, which has the eclipse or the provisions of majority of the above discontinued articles, or sorry, acts, okay, that is in the UAPA, Unlawful Activities Prevention Act, right? So legislations on preventive detention. So for reasons connected with the defense, foreign affairs and security of the country, Parliament has exclusive authority to make laws. And for reasons connected to the security of a state, maintenance of public order, maintenance of supplies and services essentials to the community, concurrent powers to the both Parliament and state legislatures are also given. Okay, so simply speaking, who can make preventive detention laws? Is it the only center, or is it only the states, or is it both? So yes, according to the preventive detention provisions, both, that is the center as well as the states, they can make laws or they can promulgate. Okay. Next, right against exploitation. Okay, what is the provisions here? And yeah, one thing I would like to add that I'm sorry, really forgot. Okay, with regard to the preventive detention. Okay, there is a very famous case as well. Okay, that is named as A.K. Gopalan. A.K. Gopalan versus State of Madras. Okay, very famous case. It was the year 1950. A.K. Gopalan, he was a communist leader from the Communist Party of India, basically. So, he was arrested, okay, and he was imprisoned on the grounds of preventive detention. And so, he challenged this particular preventive detention of his using Article 32 and directly approaching the Supreme Court of India. And he challenged this Article 22 Clause 4, that is preventive detention, of being violative of his particular fundamental rights that are guaranteed under Article 20. Okay, specifically Clause 1 and 2. That is, when he hasn't committed any crime, then why is he being imprisoned? Okay, so in that case, only A.K. Gopalan case, Supreme Court clearly opined that yes, Article 22, Clause 4 should be seen as an exception. Exception to what? As an exception to the rights guaranteed under Article 20. Okay, so the very year of the implementation of the Constitution only had the very first case related to the infringement of the fundamental rights, though it is not an infringement of the fundamental rights, as because Supreme Court has clearly stated that Article 22 Clause 4 should be seen as what? Exception to Article 20, or the rights guaranteed under whole of Article 20, right? So moving on to the next one, that is Article 23, right against exploitation. No one can exploit you, no one can subjugate you, no one can dominate you. Okay, this is what Article 23 has to state, that is prohibition of traffic in human beings and forced labor. No one shall be trafficked, that is this tradition or the customs the ancient and the medieval kingdoms they used to follow of buying the slaves, buying the humans. Sale and purchase of humans used to happen, right? So this thing, this is smuggling, this trading of humans or even the human body parts, they should be absolutely banned. Okay, so according to Article 23, it prohibits traffic in human beings. Then begar as in what? Forced labor, that is providing labor out of the force and also not providing the adequate remunerations. Okay, and other forms of forced labor as well. For example, Immoral Traffic Prevention Act has been there. Apart from that, the Bonded Labor Prohibition Act has also been enacted. The very same articles, Clause 2, what it states, state can impose compulsory service, no discrimination on grounds only of religion, race, caste or class or any of them. Sometimes in unavoidable circumstances, it can happen that state can impose some compulsory service to the citizens, and that should be not seen as the violation of Article 23. Okay, so this is what? Right against exploitation. No forced labor, no human trafficking, no begar, nothing. Okay, literally nothing. One thing that should be added, actually deleted, it is BEGAR, not BEGGAR, it should be BEGAR. Okay, begar as in making someone work without providing adequate remuneration or even not even providing any type of remuneration, that is salaries. Okay, so this is what? Right against exploitation, Article 23. Next, Article 24. One thing that is badly needed in India. Okay, prohibits the employment of children in any factories, hazardous factories and so on. So it says that basically prohibition of employment of children that is aged below 14 years in hazardous industries or any type of hazardous jobs. No children should be employed in any sort of hazardous industries. And what is the definition of children? Any individual who is less than, okay, that is below 14 years. Okay, less than 14 years. Okay, so this is what Supreme Court has stated as well. There is a case reference in the name MC Mehta versus State of Tamil Nadu. Okay, state authorities should protect the economic, social, and humanitarian rights of children. It should be the duty of the state to look after under Article 39 and 47 as well. That why the children are forced into labor at a very small age, not even young age. It should be the word small age, right? So the case reference here, MC Mehta versus State of Tamil Nadu case, right? Okay, all of you. Next, Article 25, one of the most interesting one. Right to freedom of religion. What it says. It's your choice which religion you want to practice. What is the conscience you want to have? Okay, it's absolutely your choice. That is freedom of conscience, profession of any religion, practice of any religion, promotion of any religion, or propagation of any religion. It's totally up to you. It doesn't matter if you are born in a Hindu family and you cannot promote Islam. It's your choice, you do. It's not like that you are born in a Muslim family and you cannot promote Sikhism. It's your choice, you do. It's not like that you are born in a Sikh family and you cannot promote Christianity. If you want, you do. It's absolutely not like that. That if I'm born in a Christian family, I cannot propagate or practice Jainism or Buddhism. It's my choice. Doesn't matter the family I'm born in, the surname I'm having. It absolutely has no relevance. It's absolutely my choice. Let's say if I'm born in a Muslim family, okay, those who are following Islam as their religion, okay, but if I wish to propagate or practice Hinduism, then I will do that. Or vice versa with any religion. It's absolutely whose choice? My choice. Okay, let's say for example, by propagating or promoting or practicing any one religion, I found that this second religion is there. There is another religion and that is better. So can I switch? Yes, I can switch. How many times I can switch my religion? N number of times, as much as times I want. Okay, so there is no bar, no capping, no boundary on religious practices. What religious practices? Whatever suits you, whatever you think is comfortable for me, good for me, and everything, that is it. Okay, so it covers what? It covers both religious beliefs as well as religious rituals. Okay, religious beliefs as well as religious rituals. Okay, that is conscience, profession, practice, and propagation or promotion even. Then, reasonable restrictions are there as well. That is subject to public order, morality, and health. These are the three reasonable restrictions mentioned in the first ever line of Article 25. That is what? Subject to public order, morality, health, and other provisions relating to the fundamental rights. For example, let's say freedom of belief as well as rituals, right? Let's just understand it with the recent case study. Freedom of conscience is there, right? That is freedom of belief is there. And along with the freedom of belief, there is also freedom of religious or the rituals practices, that is. Okay. So, there is a festival I have got in my religion, that is Diwali. And now, with regard to the modern ages, modern world, the celebration of Diwali is very much closely related to the bursting of the crackers. Okay, the burning of the crackers, the bursting of the crackers. See, let's just refrain this thing. Whether bursting crackers, they are right or wrong. We have nothing to deal with this. It's your choice. You think it is right? Okay, proceed. You think it's not right? Okay, let it be. Neither I am any kind of a judge here, neither you guys are to deliver the justice or the judgment, actually. Sorry, not justice, to deliver the judgment. That is, no, it's my festival. I want to burst cracker. I will. Okay, what's harm in that? Okay, and it is right, it is a religious practice. And let's just not go to the other side as well. No, it harms the environment, it harms the people, it harms the animals, yeah, wo, etc., etc. So let's just refrain from this particular topic as it is very political in nature. Okay, it was not very much political in nature, but these days it has been given political, the theme. Okay, so just taking the case reference. If you are a resident of Delhi NCR region, okay, Delhi NCR region, since last around 7 years plus 8 years, I'll say, okay, 2017 onwards, specifically from 2018 actually, Supreme Court of India, it has clearly stated that any kind of sale or purchase of crackers or even its usage is banned. Okay, in where? In the Delhi along with the National Capital Region, that is adjoining the areas of Delhi. Okay, when we focus on the words mentioned in Article 25, what it says, it covers both religious belief as well as religious rituals. This is what is mentioned in Article 25. My religious ritual is that there is Diwali and I must burst the crackers. Okay, that's a belief, that's a ritual. Then who is Supreme Court to come in between and ask me that no, 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 too much pollution, you are not going to burst crackers, this is not allowed, this is banned. This is wrong, right? Supreme Court cannot do this. This is wrong. Right or wrong, let it be, but Supreme Court cannot do this. Supreme Court doesn't have any power. Yes, Supreme Court can do this. Supreme Court has the power. See the next one. The reasonable restrictions. The doctrine of reasonable restrictions, it has also come into the picture. What is this? Subject to public order, morality, health. Morality and health. And when I burst crackers, it disturbs the health. Health of whom? The health of the humans, health of the animals, health of the environment, basically health of the whole planet. Right? See, there are people now, those who will think, sir, वो ऐसा उधर वो मिसाइल फोड़ते, इधर बम फोड़ते, इंडस्ट्रीज लगती, तभी ग्लेशियर नहीं पिघलते, तभी pollution नहीं होता, right? Yeah, that is also a very valid point. That is when you are, bombing, launching the missiles. Okay, industries are there with all excess amount of pollutants, not only in the air but water, soil, and everywhere. Noise pollution is there. E-pollution, e-waste has also come into the picture. Ozone layer, it has now, we have seen a hole in that as well, right? So when we do perform all of those activities, it is not troubling the planet, it is not troubling the global warming, okay, or not even melting the ice caps or the glaciers. But here one day when I'm bursting the cracker, it is, troubling the environment. Well, I say that's a very correct logic. Very true. Yeah. Both the points, they are contradictory to each other. Okay. But focus on the fact that with regard to the bursting of the crackers in the Delhi NCR region, which is already troubled with excess amount of pollution from land to water to air. And the very same month when Diwali happens, that is October to November, this is also the month when parali, that is rice husk, is burnt by the farmers adjoining the Delhi and its estates. That is Punjab, Haryana, Uttar Pradesh, somewhere, like all of these locations. So when the parali, that is the rice husk, is burned, their fog, the smog, it also travels towards the location of Delhi. Okay, and because of the double blow, that is the smog, okay, that is the fog of the parali, that is the rice husk burning, and the crackers, it creates a smog, that is a type of a black coating of the clouds. It happens, okay, and the gases, they do get polluted. The environment, it get polluted with some excess amount of gases from aerosols to chlorofluorocarbons, okay, and many more. Carbon monoxide, enhanced amount of carbon dioxide as well. That is for sure, troubling the environment, no doubt in that. Okay. So for that sake, Supreme Court has come into the action here and has asked the residents of Delhi NCR to not indulge in any sort of sale, purchase, or usage or bursting of the crackers inside the Delhi NCR region. And is it constitutionally correct? So yes, it is constitutionally correct. Okay, let's not go into the social customs and the social acceptance of those things. It's not a point of discussion. Okay, here talking about just whether it is constitutionally under the purview or the power of the Supreme Court or not. So yes, it is, as according to the restrictions, the reasonable restrictions enshrined inside Article 25, as well as the other one, 26, the very first ever line of the first two articles of these two articles, that is Article 25 and 26, not first but two, that is 25 and 26. Okay, the very first lines of these both articles, 25 and 26, talks about subject to public order, morality and health. You can enjoy your religion, your religious practices, propagate and promote, have conscience of any religion of your choice, but do not trouble, okay, do not trouble the factors: law and order, morality of the people, and health of the people. Okay. So there have been much more instances, like for example, the very famous bullfight practice which was happening in our beautiful state of Tamil Nadu, that was named as Jallikattu. The Jallikattu practice, or this particular bullfight event, has also been banned by Supreme Court concerning the morality. Okay, safeguarding the morality. And for that sake, Supreme Court has given the judgment. Okay. Next comes into the picture Article 26. Freedom to manage religious affairs. It's my religion. I will be the one who will be deciding how to manage it, how to celebrate it, how not to celebrate it. Okay. Absolutely no one can interfere. And the very same case, subject to public order, morality and health. Enjoy your religion, celebrate your religion with almost happiness, joy and triumph, but in case your celebration or your religious affair is disturbing others, specifically the public order, that is law and order, that is the peace system, morality and health, then the state will have to come in between and intervene. Okay, so it protects the collective freedom of religion. Right to establish and maintain religious institutions have been given here. Right to manage own affairs in matter of religion, and right to own, acquire and administer movable and immovable property as well, right, according to Article 26. But reasonable restrictions should be taken care, subject to, once again, public order, morality and health. Do not trouble these three and enjoy your religion however you want. Whatever your religion is, whatever your practice is, however you are going ahead, go ahead, no one will intervene. Okay. So this is what the concern is. And here we need to discuss a very famous case that happened in the year 2018 itself. That is the Sabrimala case. Okay. The Sabrimala temple case. The case here, 2018. Okay. The Sabrimala temple entry case. What was the case? The women, those who are in their menstrual age, that is specifically roughly between 12 to 50 years around. Okay. The women, those who are having their menstrual cycle. Okay, not just during the menstrual cycle, but in the age of their menstruation. That is roughly from 10, 12 years to the age of 50 years or like that, till the age they have attained the menopause, right? They were not allowed to enter into the Sabrimala temple as on the grounds of being impure. I don't understand how a natural process, okay, or even that is considered a matter of piousness according to many tribal customs and non-tribal customs as well. That is the monthly periods or the menstrual cycle the women they have. How it can be impure and how can it make a woman impure? Okay, those particular days when the menstrual cycle is going on, when the periods they are running, okay, that is somewhere justified, not even absolutely, but okay, somewhere justified, right? Okay, but if you say no, this particular age only, that is when the women are menstruating, it is the age when women are impure. This is absolute nonsense, right? And on those grounds only, the Kerala temple of Sabrimala, okay, they asked women not to enter the temple premises of being impure, whether they are having their periods at that time or not, whether they are having that menstrual cycle or not. But yes, when they are in the age that yes, they do possess the menstrual cycle, then also you are considered impure. So this was the grave violation of Article 14, equality before law. It was also violation of Article 15, right against discrimination. It was discrimination on the grounds of sex, that is gender. It was also type of an untouchability. Okay, women were considered impure. It was an act of untouchability. Then it was also grave violation of Article 21, right to life and personal liberty. Right? And Supreme Court has to come into the action, to the rescue for the non-violation of fundamental rights. They have to come into the rescue, right? And so a 3-judge bench, actually a 5-judge bench basically, they said that yes, this restriction on the entry of the women inside the temple of Sabrimala, and they have reference of the case as well, just it happened some couple of months back before this temple case, that is the very famous Shani Shingnapur temple in Maharashtra. Okay, so the very same references were given into both the temple cases, right? That is Article 14, it is being violated, 15 is being violated, 17 is being violated, 21 is being violated as well. And the judgment came on the grounds of Article 25, Clause 2, Subclause B. Okay, Supreme Court gave the clear-cut judgment. That is Article 25, Clause 2, Subclause B. What it says? It says that throwing open, the words are like this, throwing open of all the, literally all the Hindu religious institutions, Hindu religious institutions of public character, to all the classes and sections of Hindus, to all the classes and sections of Hindus. Okay, so this is what is mentioned under Article 25, Clause 2, Subclause B, that all the classes, all the sections from any particular caste, from any particular gender, it should be open for all of the Hindus. This is what is Article 25, Clause 2, Subclause B has stated inside the Constitution. And when a particular section of Hindus, that is the women, Hindu women, when they were prohibited from entering into the temple, it was violation of Article 14, 15, 17, 21, along with Article 25, Clause 2, Subclause B. Right? So, once again, the Supreme Court came to the rescue when it comes to the infringement of the fundamental rights of any individual. Right? So, this is it. Next. Article 27. Freedom from the payment of taxes for the promotion of religion. Wonderful. If you want to promote any religion, whatsoever expenses it is happening, okay, very politely, any expense that is happening for the sake of promotion of religion, no tax. Enjoy. Right? No tax, nothing. Enjoy, promote. Okay, and there happens the conversion of black to white. This is what the best weapon. If you have too much of black money, I don't know, right? If you're having too much of black money, use this. Approach any trust, and our, which is running any religious institution, give them the money, ask them to return the money in the name of donation from the trust, and enjoy. Now it is white money, right? Neither the government will ask you anything because it has come from the religious institution, right? So best thing, सब बाहर किसी को बोलना नहीं, ठीक है? चोरी चुपे कर लो, ठीक? What is that? Article 27, freedom from payment of taxes for promotion of religion. No person shall be compelled to pay any taxes for religious purposes. Enjoy, right? Prohibits the state from being biased towards a particular religion. No religion needs to pay tax. No religion. Okay. Create your new religion. Then also no taxes. Okay. Next, state can, however, charge fees for secular and administration or special services. Okay. For any type of secular activity that is needed. Okay. But for promotion of any religion, no tax. I get tax. Must much kato. Okay. Enjoy yourself. So, if you have in your notice anyone who has too much of the black money and is troubled how to convert this into white, explain him or her about Article 27. Okay. Mast, badhiya hai. Very nice. Next comes into the list, Article 28, freedom from attending religious instructions in educational institutions. Okay. If there is any religious instruction that are imparted in any educational institution, then you have absolute power, absolute authority, absolute right to attend or even not attend that particular religious instruction. Whether it is a school, it's a college, or any other type of the educational institution. If any such type of religious instructions they are being provided to you, you have got the absolute authority to refrain from it or just accept it as well. Okay. So basically this particular article, it divides educational institutions into 4 categories. And guys, the categorization is very, very important. Okay. So please pay very prior attention. Very important it is. So firstly, if a particular institution is there which is wholly, that is totally, wholly, that is totally, okay, okay, wholly, that is totally maintained by the state. Okay, so in that particular institution which is totally maintained by the state, that is by the government, religious instruction is not permitted, absolutely not permitted. Okay. Next, if the institution is recognized by the state, religious instructions is permitted on voluntary basis. If it is a state recognized institution, not funded or maintained by it, recognized, okay, then it is up to you whether you want to attend. Okay, it is absolutely voluntary. If you want to attend, go ahead. If you don't, you can deny, both at the same time. Third, a particular institution that receive aids, that is the grants, that is basically the funding, the money by the state. Say, religious instructions, they are permitted, once again, on what basis? On voluntary basis. That is, you can accept or deny on the same. Fourth, administered by the state, but condition is there, established under a religious endowment. That is a particular institution that has been made for religious instructions only. Like for example, we have got madrasas in our country. Okay, so madrasas, they are what? They are administered by the state, right? But is there any religious instructions provided inside our madrasas? Yes, they are. So this is violation? No, it is not violation, as no restrictions on religious instructions. Okay, it can be given. Okay, right? So this is what the fact is. Any religious institution that is created or maintained by the state, but it is a religious institution only, educational institution, but having the theme of religion. Just for example, madrasas. Okay, in there, no such restrictions does exist. Okay, guys. So this is what Article 28 is all about. And when we just go ahead, a very famous case is also there. related to our national anthem as well as religious freedom. The case is known as Jehovah's Witnesses case. Jehovah's Witnesses case. Okay. 1987. If I'm not wrong with the year, it is 1987. Okay. It is also known as Joseph Emmanuel versus State of Kerala case. What does this word means? Jehovah's Witnesses. So Jehovah's Witnesses, actually it is a name of a religion. Yes, you heard it correct. Jehovah's Witnesses is the name of a religion. A micro minority religion, that is minority in minority they are. Okay. A religion which is obviously very pious. Any religion is obviously pious. So Jehovah's Witnesses, okay, they have got a distinct set of rules, customs and traditions. Okay, a distinct God as well, obviously. That is why a distinct religion it is. So they are named as Jehovah's Witnesses, and it happened in 1987 around. Okay, that in a school of Kerala, national anthem was being sung. And there were some couple of students from the very same religion, that is Jehovah's Witnesses. And the teacher observed that the children, they are not singing the national anthem. So after the anthem ended, the teacher called those kids and asked them to sing, so they denied. So infuriated teacher, she sent her to the principal, and in front of the principal also they denied. Principal called the parents, and the parents, they came in, and when the principal narrated the whole story, the parents stated that yes, our children are not wrong, they are correct. We cannot sing the national anthem as it is against our religious customs or the protocols. Okay. So the matter took a very violent turn, and it went to be the violation of the fundamental rights of the individuals. Hence, they both went directly or approached directly to the Supreme Court of India. Okay, the parents, they went to the Supreme Court for the sake of infringement of their fundamental rights. Okay, for the reinforcement of the fundamental rights. So in that case, Supreme Court opined that singing national anthem while it is sung, it is not mandatory. Okay, according to the protocols of national anthem. When national anthem is being sung, is being played, okay, it is not mandatory for everyone to sing it. But, the catch. It is important for us to stand in respect, that is, stand in attention when the national anthem is being played. See, singing is voluntary. Okay, though I personally say that yes, you must sing as well. But this is what, according to the laws, is voluntary in nature. Okay. The fact is, what Supreme Court has also stated, and what we as citizens must also do this always. That is, whenever the national anthem is being played, okay, we must stand in attention and provide proper respect to our national anthem. Okay. The Jan Gan Man is not just some, these lines. They represent the national heritage and freedom struggle of the country as well, right? So guys, please be very, very specific. The case name, Jehovah's Witnesses case, 1987, okay? And apart from that, the very next thing, what is that? Also known as Joseph Emmanuel case. What Supreme Court opined? That whenever national anthem is being sung, it is not important for everyone to sing it, but yes, it is important for everyone to pay attention, stand in respect of the anthem, national anthem, right? Okay. So moving to the segment that is MCQs. Here we go. Which of the following is not a fundamental right under the Indian Constitution? Not a fundamental right. Right to equality, right to freedom of religion, right to property, and right against exploitation. So obviously we have discussed it. It is right to property, which was once upon a time till 1978, but has been repealed with the 44th Constitutional Amendment Act, which was mentioned under Article 19, Clause 1, Subclause F, and apart from that, Article 31 as well. Now it is a constitutional right, that is a right outside Part 3, okay, under Article 300, capital A, okay, that is mentioned in Part 12. Next, a law made by the Parliament places restrictions on free speech under Article 19, Clause 2, that is the exceptions to the free speech, claiming reasonable restrictions on the grounds of public order. The Supreme Court can strike down this law if, when, what is the condition? The restrictions imposed are excessive and disproportionate to the objective. The law is vaguely worded, allowing arbitrary application. The Parliament did not follow the due process of the law while passing the law. So what is the correct one? 1 and 2, 2 and 3, 1 and 3, or all 1, 2 and 3? In case Article 19 Clause 2 has been used to legislate a law that restricts the freedom of speech and expression of the citizens, so what is the fact? When can Supreme Court strike it down? In what condition? Okay, 1, 2, 3, or any one of them, any two of them, or all of them. So the correct answer is B, that is 1 and 2 only. The correct answer is 1, as we have got the case reference in Chintaman Rao versus the state of MP 1951. The Supreme Court ruled that the restrictions must be reasonable and proportionate to the intended objective. Okay, excessive restrictions, okay, they are not allowed. Statement 2 is also correct. That is in the Shreya Singhal versus Union of India case of 2015. The Supreme Court struck down section 66 capital A of the Information Technology Act. Okay, ruling that the vague laws allow arbitrary application and violates free speech. So statement 3 is incorrect, as that is due process of law is applicable only to Article 21 and not Article 19. Right? So Parliament only needs to follow the procedure established by law while making the laws restricting free speech. Okay, so the case reference, guys, the Chintaman Rao versus state of Madhya Pradesh and Shreya Singhal versus state of Union of India. Chintaman Rao case 1915, Shreya Singhal case 2000 and Chintaman Rao case 1951 and Shreya Singhal case 2015. Next, which of the following hypothetical situations would amount to violation of the right to equality under Article 14? Hypothetical. Okay. First, the government passes a law giving tax exemptions only to businesses run by a specific caste groups. Second, a private company refuses to hire women for a managerial role. Third, a law imposes stricter pollution control norms on industries in urban areas compared to the rural areas. And fourth, a university provides a reservation for the SCs and STs in admissions. Yes, guys, what do you think? Correct answer 1 and 2, 1 and 3, 2, 3 and 4, 1, 2 and 3. So what should be the correct answer? So the correct answer will be D, that is 1, 2 and 3 only, as the fourth one is not correct, as the Article 15 only provides for the exception, that is with regard to the reservation for the backward classes, women, children, economically weaker section, along with the scheduled castes and the scheduled tribes. Okay, so this is not the violation in case a particular reservation has been provided under Article 15 clause 4 and 16 clause 4. Okay. Next, the Supreme Court has expanded the scope of Article 21, that is right to life, through various judgments. Which of the following is not covered under Article 21? Okay. Right to clean environment, right to speedy trial, right to reservation in government jobs, and right to livelihood. Not included. Okay. So obviously clean environment is needed. Speedy trial is also it's a right, fundamental right. Right to livelihood is also there. What is the correct answer? C, that is right to reservation in government jobs. It is not a fundamental right under Article 21. So clean environment is there. MC Mehta case 1987. Speedy trial, Hussain Nara Khatun case 1979, through which also the principles of judicial review came into the impetus. Then right to livelihood, Olga Tellis case 1985. Okay, reservation in government jobs is not a fundamental right but a policy or a decision under Article 16 clause 4, as well as one more thing to be added 16 clause 4 and another article, that is 16 clause 4 capital A. 16 clause 4 talks about the backward classes, and specifically 16 clause 4 capital A for the scheduled castes in the terms of promotion, in terms of reservation for promotion if the state thinks the community is not adequately represented. Okay, so Article 16 clause 4 and 16 clause 4 capital A. Okay. Next, which of the following principles guides the application of Article 14 in India? Is it intelligible differentia test, the manifest arbitrary test, the basic structure doctrine, or the golden triangle principle? What is the correct answer? 1 and 2, 2 and 3, 1, 2 and 4, 1, 2 and 3. So I believe Yes, it will be difficult to answer this one as there are many new segments that are being mentioned here. So no problem. So the correct answer is option C, 1, 2 and 4. Okay, 1, 2 and 4, that is intelligible differentia, basic structure doctrine, intelligible differentia, manifestation of arbitrariness and the golden triangle principle. So these are what? The guide or the applications for Article 14. So let's see what are they. So intelligible differentia test established in the state of West Bengal versus Anwar Ali Sarkar 1952, which requires that a classification must be reasonable and have a rational nexus to the objective. So whatsoever is happening, it should be reasonable in nature. Whatever you are classifying, it should be based on reasonable grounds. Okay, so that is known as intelligible differentia. What is the name of the case? Anwar Ali Sarkar versus West Bengal, state of West Bengal, 1952. Next comes the manifest arbitration test or arbitrariness test actually. Introduced in Shaira Banu versus Union of India case, that is triple talaq case. Okay, it invalidates laws that are capricious or discriminatory, basically discriminatory. Then golden triangle. Golden triangle is what? How do we justify the thing that is known as golden triangle? So at the vertex we have got Article 14 and at the base we have got on the one side Article 19 and Article 21. The golden triangle rule. This triangle is what is called as golden triangle. Okay. Triangle as in obviously three angles and three angles that are representing three articles 14, 19 and 21. Okay, this is what golden triangle. If any of the fundamental right from the golden triangle is violated, the other two, they are by default violated. And guys, don't worry about this particular tests. That is what is intelligible differentia, what is manifest arbitrariness, okay, and the golden triangle. We will be discussing them in detail in the next class. Okay, so don't worry. The arbitrariness, and apart from that, the intelligible differentia, basic structure doctrine, golden triangle principle, everything we will discuss in the next session. Okay, so need to relax. Which of the following cases did the Supreme Court hold the fundamental rights can be enforced against private individuals in circumstances? Fundamental rights, they do provide us protection against the arbitrary action of the state and not individuals. But there are some fundamental rights that can be imposed against the private individuals as well. Like for example, Article 17 and Article 21. Okay, that is for the state as well as individuals. So in which case particularly Supreme Court appointed this? So is it the Keshwananda Bharati versus the state of Kerala, Vishakha versus state of Rajasthan, Golaknath versus state of Punjab, and A.K. Gopalan versus state of Madras? So in 1997, a very deadly event happened, out of which the Vishakha guidelines were also created. Okay, and through this case, that is the Vishakha versus state of Rajasthan case, Supreme Court stated that fundamental rights can be enforced not just against the state but also in case of violation by the private individuals as well in certain circumstances. Okay, so what are these certain circumstances? When it is the violation of Article 21, or apart from that if it is the violation of Article 17, or apart from that if it is the violation of Article 23. Okay, so in all such cases, okay, from 14, 21, 23, okay, and 17 as well, the fundamental rights, they can be enforced against the private individuals. Which of the following cases establish the fundamental rights cannot be waived by any individual? There is a particular doctrine, okay, don't worry, we are having the doctrine series as well. That is the doctrine of waiver. That is, you can waive off your fundamental rights whenever it is not needed by you. Like, for example, okay, when you talk about doctrine of waiver, our Prime Minister, a couple of years back, he mentioned that whosoever individuals are eligible, or eligible, not the word is, those who are good enough, economically sound, and still they are taking LPG subsidies, they should give up their LPG subsidies so that the actual beneficiaries could get those subsidies. Okay, so some lakhs, okay, I don't remember exactly the figure, some lakhs individual, they gave up their LPG subsidy. And that is what? Subsidy is the right of a citizen. Okay. But people, when they gave up their subsidy, that is a right. That was considered under the doctrine of waiver. Okay, that is waiver, when you waive off, that you give away your fundamental rights, not fundamental rights, actually your rights. You cannot, even if you want, you cannot give up your fundamental rights. They are mandatorily imposed. Okay, so according to the doctrine of waiver, even if you are willing to waive off your fundamental rights, you cannot. You can waive off your other legal or the constitutional rights, but not the fundamental rights. And subsidy is not a fundamental right, it is a constitutional or a legal right. Okay, so which of the following cases it was? Okay, where Supreme Court stated that fundamental rights cannot be waived by an individual. Okay, so is it Olga Tellis versus Bombay Municipal Corporation, Basheshwar Nath versus Commissioner of Income Tax, PUCL versus Union of India, or is it KS Puttaswamy versus Union of India? Okay, so what is the correct answer? It is B, that is Basheshwar Nath versus Commissioner of Income Tax. Okay, here it was stated that even if you are willing to, you cannot waive off your fundamental rights. You can waive off any of your other constitutional or legal rights, but not fundamental. Okay. So guys, that's it with this session on fundamental rights, along with the MCQs related to the previous chapters as well. Thank you so much for watching, guys. And these are my social media handles as well. So wherever you are willing to connect or comfortable, you can connect. You want to connect with me over my Instagram. So it is with the username Praveen Mishra _2107. Or apart from that, we have also got the Telegram channel for you. That is Study with Praveen. So the name goes Study _with _Praveen. So wherever you guys are comfortable, you can connect. Okay. Thank you so much, guys, for watching. See you all soon, and please do provide the homework. Okay, that is the question of judgment that we were discussing. So please do let me know into the comment section, and please subscribe for the channel if you haven't done yet. Bye bye. See you all soon in the very next session. Bye bye. Good day. Take care. Actually, good night.